You know how a small, nagging neighborhood problem can just escalate? Well, this is one of those stories. It starts with a simple puddle, and it ends in a formal legal hearing. It's a perfect example of how the fine print in our community rules can have some really big consequences.
So picture this, the MountainGate community. After the heavy monsoon rains, which happen all the time, a common area behind a few homes just kept flooding. It was a recurring, soggy mess. You'd think, okay, easy problem, easy fix. Well, the Homeowners Association, the HOA, came up with a plan. Let's dig a drainage ditch. Problem solved, right? Not so fast. One homeowner took a look at that plan, then took a look at the community's governing documents and said, hold on a minute, you can't do that.
And what happened next wasn't just a few angry emails. This thing went all the way to a formal administrative hearing. So today, we're going to walk through the whole thing. The actual arguments, the evidence, the verdict, all pulled straight from the official court records to see what happens when the rules themselves are up for debate.
All right, so let's set the stage for this neighborhood showdown. It's a classic case, really. On one side, you've got a homeowner trying to hold the board to the letter of the law. And on the other, you have a board just trying to fix a very real, very wet problem.
So the man who filed the complaint, the petitioner, is Harry G. Turner. He's a longtime resident, even a former board member himself, and he's going up against the respondent, the MountainGate HOA, the very board in charge of running the community. The whole fight is over one little piece of land called Tract H. Okay, so let's get into Mr. Turner's side of the story. It's important to know his argument wasn't really about the ditch itself. It was about how the HOA was trying to get it done. He was convinced they were breaking their own rules.
At the hearing, Mr. Turner's entire case rested on the official label for Tract H. See, in his view, this wasn't just some spare land. It had a specific designation, a preserved common area, and that came with some serious protections.
And he brought receipts. He presented the community's official plat map, the architectural blueprint for the whole neighborhood. And right there in black and white, the tract data section calls Tract H preserved/active open space. Not drainage area, but open space.
Then he connected that map to the community's own rulebook, their CC&Rs. He pointed to Article 10, Section 4, which is super clear. It says that if you want to make a change of use for a common area, say from open space to something else, there's a whole process you have to follow.
And it is a high bar. That process requires a 2/3 majority vote from all the homeowners. So, Mr. Turner's argument was simple. Digging a ditch is a massive change of use, and the HOA was legally obligated to put it to a vote, period. And here's the smoking gun, or so he thought. Mr. Turner presented an email from the HOA's own lawyer from a year earlier. In it, their attorney basically warned them that this was a gray area and that, quote, the path to least risk would be to put the issue to a membership vote. I mean, wow!
So you're probably thinking that's a slam dunk for the homeowner, right? Well, the HOA's response was pretty clever. They didn't deny any of Mr. Turner's evidence. Instead, they used the very same map to build their own completely opposite case.
And this is where the whole case gets wild. It turns out the plat map was contradictory. Yeah, the part Mr. Turner showed said preserve/active open space. But the HOA pointing to a different section on that same map, a section that said Tract H was to be used for open space, landscaping, and drainage.
So the HOA's argument was, look, we're not changing anything. They claimed that drainage was part of the original plan for that land all along. It says so right there on the map. They argued the original developer just never got around to actually building the drainage, so they weren't changing the use, they were just finishing the job.
And to make it clear, this wasn't just some abstract legal debate. The HOA showed pictures of the flooding. Their secretary, Brenda Anderson, testified that this was a chronic issue, year after year. For them, this was about solving a real problem that was affecting their neighbors' properties.
So, just imagine you're the judge here. You've got two sides, both using the exact same document as their primary evidence to make completely opposite points. One says open space, the other says drainage. How in the world do you decide who's right?
I mean, really, what do you do? When your main piece of evidence says two different things, which part do you believe? Does one section of the map have more legal weight than another? It's a real legal puzzle with no obvious answer.
Well, in the end, the judge made a call. Mr. Turner's petition was dismissed. He lost. Despite his evidence, despite the email from the HOA's own lawyer, the judge sided with the association. The HOA was free to start digging, no vote required.
The big question, of course, is why? With the evidence so split, how did the judge land on that decision? And the answer comes down to a fundamental concept that governs our entire legal system.
It's called the burden of proof. And what it means is that the person who brings the complaint, in this case Mr. Turner, has the job or the burden of proving their side of the story. It wasn't the HOA's job to prove they were right. It was Mr. Turner's job to prove they were wrong.
And this chart lays out the judge's thinking perfectly. Because the plat map said two different things, the document itself was legally ambiguous. It was unclear. Since Mr. Turner couldn't prove that his interpretation was the only correct one, he couldn't definitively prove that the HOA was violating the rules. He failed to meet his burden of proof. And in court, if you can't meet that burden, you can't win.
And that leaves us with a really fascinating question to think about. This whole expensive legal battle came down to a mistake, a contradiction written on a map decades ago. So when ambiguities like that pop up in our own community rules or contracts, who should have to bear the risk? Is it the individual homeowner who has to live with the outcome? Or is it the collective organization that's supposed to represent everyone? It's something to think about.